S16A 0537, Bianca Thrasher-Starobin versus Michael Starobin. Bianca Thrasher-Starobin appellant, Lawrence Zimmerman for appellee.
Each side is allotted 20 minutes for argument. You're not required to take all the time. You are allowed to use up to the full 20 minutes if you'd like, but you'll need to keep up with your own time. If you run out of time, we'll sound a bell to signify that your time has expired. But there is a clock on the bench, on this bench, and there's a clock on the podium. There's even a clock on the wall behind me. You may proceed when ready.
Thank you, Justice Thompson. Thank you so much for taking the time. I really appreciate the opportunity to have my case heard. I filed this application, and it's very important to me, and I've put a lot of time into researching the case, the law, and the case study because I cannot afford to get this wrong. Divorce can get ugly and spiteful in certain regards, but things ended up in the transcripts and the final divorce decree that were untrue, unjustified, and fundamentally unfair, and that is why I'm here. I'd really like to be clear that this case is not just about religious freedom or attorney fees. I often wondered if I was being discriminated against because I'm a Christian. I was wondering why my ex-husband got all the Jewish holidays and that I got none. The process never seemed fair, and the results never seemed justified. I won't lie to you. I do believe that fundamental fairness is at play in this case. Throughout this entire process, provisions were made and constantly being made right into Mr. Zimmerman being allotted additional time to prepare for the case and me being denied that time to find an attorney. Thankfully, I was working for a legislator at the Capitol, and I was able to hire Representative Jones to represent me. I filed an application seeking relief on multiple grounds from the final divorce decree and order, amended final order on petitioner's motion for contempt, and respondent's counterclaim of contempt against the petitioner against request for attorney fees, and petitioner's ex parte temporary protective order by the trial court sitting without a jury. In Bianca Thrasher-Starobin petitioner versus Michael Starobin, respondent case number 2013 CV 226609 and 2014 CV 23754 in the Superior Court of Fulton County. The first issue was the attorney's fees, and it has been acknowledged by Mr. Zimmerman that the trial court failed to state the statutory basis for its award pursuant to Section 1962 and OCGA 9514, also citing the McCarthy versus Ashman-McCarthy, Leggett versus Leggett, award of attorney fees, abuse of discretion by the trial court. As I had mentioned before, Mr. Zimmerman has agreed that the trial court award of attorney fees should be remanded. The other issues in the enumeration of errors were the refusal of the court to consider evidence of rape during the testimony. I believe that it violated statute OCGA 1993, which is best interest of the child, stating that the judge shall not refuse to consider relevant or otherwise admissible evidence of acts of family violence merely because there has been no previous finding of family violence. P, also, any evidence of family violence or sexual, mental, or physical child abuse or criminal history of either parent by refusing to hear evidence of the rape. And then if you could look at the transcript the first transcript, actually, respectfully, I'm requesting that. Page 152, line 25, and page 154, line number 10. I believe that the trial court abused discretion when not agreeing to admit evidence, which was text message evidence of my ex-husband admitting to raping me. The next issue in the enumeration of errors is religious freedom and First Amendment rights. On the transcript, page 73, my ex-husband requested from the court Jewish holidays. On page 159 of the transcript, I requested Christian holidays, specifically Good Friday and Easter. I believe that it is fundamentally unfair that my ex-husband was awarded Jewish holidays and I received 0 Christian holidays. The standard for determining whether bias or prejudice, as that term is used in section 144 and 455, is whether a reasonable person with knowledge of all facts would conclude the judge's impartiality might reasonably be questioned. This is an objective standard, so that what matters is not the reality of bias or prejudice, but its appearance. The court holds that opinions arising during the course of judicial proceedings require disqualification under section 455 only if they display a deep-seated favoritism or antagonism that would make fair judgment impossible. And the cases that I cited were Lickety versus United States for abuse of discretion. The next one was parenting coordinator. In the final divorce decree, it is ordered by the court that my ex-husband has the right to hire and fire the parenting coordinator. And if I am unable to afford to pay the parenting coordinator, that I forfeit the right to see my son. To state that I am unable to pay the parenting coordinator, I believe is unfair and unjustified. It doesn't seem like this, in this country, if you cannot afford to see your child, that you can't see your child. It's like a debtor's prison. Katz versus Katz, 264 Georgia 440, I'm citing it like an abuse of discretion. Bless you. The court reversed the judgment, placing limitations upon the visitation of the parties' children in this divorce action. The court remanded the matter in the order for the trial court to reconsider the issues of custody and visitation in light of the court's opinion. Also, Arnold versus Arnold, thus the trial court abused its discretion by placing an unauthorized restriction on the wife's exercise of her right as a custodial parent. In Miller versus Wallace, 76-479, Justice Hall, in discussing the section of the code which allows the judge to exercise discretion as to whom custody of the child shall be given, when it gave the right of custody to the child, of a child to a third party. It is stated that discretion to be exercised in such a case is not an arbitrary or unlimited discretion like that confident to Roman praetors, but as remarked by Lord Mansfield, is such a discretion as when it is applied to the court of justice means sound discretion by law. It must be governed by rule, not by humor. It must not be arbitrary or vague or fanciful, but like legal and regular. I'm looking at the time, so I'm going to skip some. And I'd like to move on to the next enumeration of error, which would be custody. My son lived with me the entire time prior to the divorce decree. Per the transcript, I took him to all of his doctor's appointments. I knew all of his maintenance needs. I did have arranged play dates, and he was 2 years old and learning to be potty trained. Under section OCGA, the statute states that in determining the best interests of the child, the judge may consider any relevant factor, including but not limited to the love, affection, bonding, and emotional ties existing between each parent and the child, the capacity and disposition of each parent to give the child love, each parent's knowledge and familiarity with the child and the child's needs, the capacity and disposition of each parent to provide the child with food, clothing, medical care, and day-to-day needs, the home environment and the importance of continuity in the child's life and the length of the time that the child has been in a stable environment While the trial court may consider the conduct of parties on the issue of custody, the court ultimately must decide that the custody question is based on the best interest of the child. Mock versus Mock, 258 Georgia 407. Indeed, the welfare of the child is the controlling factor in the court's determination of custody. Taylor versus Taylor, 280 Georgia 8889. In my case, it is apparent from the records and the transcript of the motions hearing that the welfare of my son was not the controlling factor in the custody decision. A parent living with a relative can never be awarded custody, Hicks versus Hicks. The trial court did not evaluate or make any determinations as to the best interest of my son Moses, and instead simply followed its own personal policy of abusing its discretion. The next issue was psychological evaluation. In the final divorce decree, it was ordered that I have a psychological evaluation and not my ex-husband. And permitted by section 19937, the court can order a psychological evaluation to determine the mental and physical health of each party. In section OCGA 1993, only I have been ordered to get a psychological evaluation, and that was fundamentally unfair. The next issue in my enumeration of errors was the sale of the Volvo violating the standing order. And the case that I cited was C's Joint Venture and C's 290 Georgia 719. The transfer or the sale of property was subject to the divorce proceedings and equitable division of property. Nowhere, for some reason, nowhere in the records is there any information about this emergency hearing where my ex-husband was completely authorized and permitted to sell the Volvo, leaving me with no vehicle, and I was not awarded any compensation for that. Another enumeration of error is regarding the transcript. In the final divorce decree, it is stated that I wanted to live in Buckhead, and the transcripts are inconsistent with the actual dialogue that took place in the court. Nowhere in the transcript does it say that I wanted to live in Buckhead. Midtown, I did say on line 143, number 8. I'm not certain if this is ex parte communication or abuse of discretion, but the information is inconsistent. The opposite of that is also true, because the judge accused me of not pressing charges against my ex-husband for financial reasons, and she also said that she did not believe me regarding the rape. In another enumeration of error, I cited the child support. In Dupree versus Dupree, let's see. The child support award to my ex-husband was improperly calculated, and in certain circumstances, earning capacity rather than gross income may be used to determine child support. And while a party's past income is some evidence of earning capacity, it alone is not conclusive, but must be considered along with other relevant circumstances. Duncan versus Duncan, 262 Georgia 872. Many other factors are needed to be examined in order to determine the earning capacity, including a party's education and many specialized training or skill. Whether there is any evidence of the suppression of income, the presence of assets and liabilities, and the existence of other funds available to the party, which the award may be paid, and that's Bancio versus Bancio, 282 Georgia 616. These factors were not all considered in my case. I had no assets, had recently filed bankruptcy, and I did not agree to the calculation of child support. In order to sustain an award of child support premised upon the earning capacity, there must be evidence that the parent then has ability to earn an amount sufficient to pay the award. Otherwise, the award cannot stand. It's stated in the financial affidavit, I believe, that my ex-husband was earning $63,500, but also in the financial affidavit, he had been gifted $30,000 from his parents, and I believe that takes the annual income over $75,000. The next enumeration of errors would be in the final divorce decree where my ex-husband is awarded the right to get a passport. My ex-husband, as is mentioned in the transcript, was born in Moscow, Russia. And then further, on page 74, he said that he did not want my son to have a passport. That's in the transcript. And he should not, but he was given the right to apply for and to maintain a passport exclusively by the trial court. We had an emergency hearing in 2013 for which there is no record again where the trial court ruled that I was not permitted to have a passport. The reason that I'd requested that passport was because I had an ailing grandmother in Trinidad and she'd not had the opportunity to meet my son. I believe that this was fundamental and unfair abuse of discretion. Another enumeration of error I cited was the marital residence. There's no evidence that I agreed to giving up my share of the marital property. I'm appealing the award of the marital residence at 1897 Spring Avenue Northwest and Mitchell versus Mitchell. My home at 5450 Sweet Springs Drive was already in foreclosure. The property was not divided equitably. My name was on the deed for the marital residence at 1897. But based on that transfer of property, I would like a cash award or my fair share of the division of that property. Equitable division of property, even if no cash was available to satisfy the award. The order is inconsistent with the evidence. Reading these horrible things about yourself in the final divorce decree that you know to be untrue and then have further stated to be untrue in my counterclaim for the motion for contempt it's very hurtful. It's something that will follow me for the rest of my life, and I'm praying that the court will consider all of these enumerations of errors and give me the opportunity to have another trial, or depending on whatever the circumstance may be, remand the decision. And I'd like to reserve the 4 minutes and 25 seconds for rebuttal.
Yes, ma'am.
Thank you.
Mr. Zimmerman.
Good afternoon, Justices. This will be the shortest argument you'll have heard all year. On April 13, 2015, this honorable court passed an order granting Ms. Thrasher's appeal for the attorney fees, and to my understanding, the only issue before the court were the attorney fees. And we've reached out to the opposing party and said we agree. There's nothing in the order that stated which statute was under, and as the law is McCarthy versus Ashman McCarthy, 295 Georgia 231 at page 234. It is required, and since it's not there, this honorable court is just required to vacate the order and remand it to the trial court. And we agree with that. That's all I put in my brief, and we've told the opposing party that. And we ask that the court do that and let the trial court either have another hearing or issue another order that cites the correct statutory basis.
Can I ask, there shouldn't really be another hearing, right? You don't have the opportunity to add new evidence. The court needs to decide based on the existing evidence whether there was a ground under either statute and the amount of the fees based on that evidence?
Correct. I think under 915-14, which was the request, I think the court could just make a better findings of fact and cite that statute. So yes, we don't need another hearing. If there's no further questions, I have nothing else to add.
Thank you.
Thank you.
Any rebuttal?
No further questions.
Well, let me thank both sides for your presentation on this case. Let me thank Judge Reeves for coming up and sitting with us. We're going to take a short recess. Everybody's at liberty to move about if you like.